Today, I am going to talk about the classical theory of human rights. History maintains that rights are a product of a long historical evolution of society. They are based on customs and traditions which one possess practical utility and pass on from one generation to another, such that with the change of time and circumstances, rights also changes. In fact, rights are the crystallization of customs and traditions. All societies, whether primitive or modern, possess a notion of dignity, equality, non-discrimination, and access to justice. Therefore, human rights have a preoccupation with values and possess at the heart of social justice. Theories of human rights. In order to gain the basic understanding of human rights, one should look at certain theories of the subject so that the shifting priorities of rights during different phases of history could be observed. The function of theory, however, is to provide an analytical tool by which it is possible to determine the precise subject matter of the concept upon which there might be an agreement. Precise insights into the major theories of rights are as follows. First, the theory of natural rights. The doctrine of natural rights is simple in explanation. It aims to emphasize that certain rights are so essential to any real personal life that they should be called natural. This idea rests on a belief in nature as the original creating force which gave to every man the power of finding by reason the right principles on which to organize his life. These principles, it is claimed, are based upon the universal law, the law of nature, and are common to all people in all countries. They are the product of human nature, that is, all men are born with certain rights, and these rights are inalienable. This is the earliest theory of rights, and its origin can be traced back to the ancient Greeks. According to this theory, rights belong to man by nature and thus are self-evident truths. They were considered as inborn, absolute, pre-civil, and according to some even pre-social. They can be asserted anywhere and everywhere. Thomas Paine, Grotius, Tom Paine, and John Locke, to name a few, are the main exponents of this theory. These theories derive their ideas about rights from God, reason, moral assumption. To them, every individual possesses a unique identity and is expected to account his action as per his own conscience. However, critics of the natural rights theory argue that rights are not abstract, absolute, or unidentified phenomenon. Liberty, as they argue, lives within restraints. So, restraints upon right create social conditions where everyone has a share to develop his personality and correspondingly has his obligation to others. Rights and the obligation, in fact, are the two sides of the same coin. Despite the above shortcomings, the theory of natural rights inspires the idea that any kind of unjust, arbitrary, or oppressive treatment to human being is an assault upon humanity itself. Apart from this, it also provides that the basis for the English Revolution, the French Revolution, and the American Revolutions, thereby resulting in the Bill of Rights. Second, the legal theory of rights. According to the legal theory of rights, there are no rights which are inherent in man. They are created and maintained by the state. Neither they are prior nor anterior to the state. The state formulates or defines rights, restricts their scope, and provides guarantees for their enjoyment. Since the state is the source of all rights, there can be no rights without or against the state. to have rights against the state is tantamount to saying that the individual has no right at all. This theory is a reaction against the theory of natural rights. Advocates of this theory argue that the idea of natural law and the natural rights are abstract and ridiculous phenomena. Hence, the existence and enjoyment of fundamental rights of an individual could be better maintained and practiced by the state rather than by the individual himself. Thomas Hobbes, John Austin, and Jeremy Bentham are the propounders of this theory. According to them, rights are purely utilitarian concepts, and thus the rule and regulation are necessary for the identification and protection of one's rights. Towards this end, every individual has to sacrifice certain rights and freedom for the general welfare of the society. This theory has been severely criticized on the ground that law alone does not create rights. Rather, it recognizes and protects them. Customs, tradition, and morality also have a basis for rights. Individuals have the right to demand certain specific and recognized rights as granted and guaranteed by the state. Third, the historical theory of rights. The historical theory of rights emphasizes that rights are the product of history. They have their origin in customs which one possesses practical social utility and pass on from one generation to another, ultimately having been recognized as inherent claims or rights. Ritchie says that those rights which people think they ought to have are just those rights which they have been accustomed to have or which they have a tradition of having one possess. Custom is primitive law. In explaining natural rights, advocates of the historical theory maintain that customs is their sanction. They are considered fundamental to the development of man because they have been maintained by a long unbroken custom and the generation have habitually followed them. Habits are natural as they grow. They are neither instituted nor are they invented. Burke maintains that the French Revolution was based on the abstract rights of men, whereas the English Revolution was based on customary rights of the people of that country. There is much truth in what Burke says. The French Revolution itself was the result of the conditions that prevailed in the country, but its slogan was liberty, equality, and fraternity, the three abstract principles of universal application. The Glorious Revolution, on the other hand, was simply a reassertion of the historic liberties of Englishmen, which had been their heritage since the days of the Anglo-Saxons and had found their expression in the Magna Carta, the Petition of Rights, and various other documents of constitutional importance. There is much truth in the historical theory of rights, and many of our rights really find their origin in primitive customs. It does not, however, mean that the origin of all rights can be traced to customs and traditions. When rights are rigidly tied to customs alone, we altogether ignore the dynamic nature of society and accordingly the changing contents of rights. Rights change with the fact of time and place. History as such is not the only basis of rights, and the customs do not provide an absolute right or standard. 4. The moral idealistic theory of rights. The idealistic theory of rights is also designated as the personality theory. According to this theory, rights are the external conditions essential to man's internal and real development. Cruz accordingly described the system of rights as the organic whole of the outward conditions necessary to the real life. Similarly, Henry C. defined the right as that which is really necessary to the maintenance of material conditions essential to the existence and the perfection of human personality. In brief, the idealistic theory emphasizes the creation of those conditions which help man to reach the fullest stature of his personality. Perfection of human personality is the end to which all rights are directed and subordinated. In other words, right to personality is man's fundamental rights, and all other rights are derived from it. The idealistic theory of rights appeals to the morals and democratic mind of man as it relates right to morality rather than legality. Secondly, it does not subordinate the self-development of man to the social whole. Both act and react upon each other. The theory believes with Kant that no man is to be treated as a means to another's end. It calls upon everybody to treat humanity in his own person and in the person of others always as an end and never merely as a means. Fifth, the social welfare theory of rights. The advocates of the social welfare theory holds that rights are conditions of social welfare. They are the creation of society, and therefore law, customs, traditions, and the natural rights should all yield to what is socially useful or socially desirable. What is socially useful should have for its test the greatest happiness of the greatest number. Take, for example, the right to speech. It is not an absolute right, it is limited by the social need of a coordinate body. Similarly, the right to property does not mean the right of the few to prosper at the cost of the many. The utilitarians Bentham and Mill are the real exponents of the social welfare theory of rights. They set up the principles of the greatest happiness of the greatest number and made it the criterion of utility. But utility, they believe, should be determined by consideration of reasons and experience. Lasky, too, accepts utility as the basis of rights, though he gives to the term a meaning which is consistent with the modified conditions of his times. He holds that the test of a right is utility, and the utility of a right is its value to all the members of the state. The claims, he says, which the state must recognize are those which, in the light of history, involve disaster when they are unfulfilled. We have rights so that we may contribute to the common good. My rights are accordingly built upon my contribution to the well-being of society. I cannot have rights against the public welfare, for that ultimately is to give me rights against a welfare which is intimately and inseparably associated with my own. Rights as such are built upon their utility to the individual and the community. The social welfare theory of rights has much to commend, but one can't say that social welfare actually means. Does it mean the greatest happiness of the greatest number, majority interest, or what is today understood to be the common good? In fact, much political wrong has been done during recent times to the individuality of man in the name of social good. The individuality of man and his rights have very often been sacrificed in order to extol social good in the name of the social expediency. A social system which discounts individual personality and glorifies the common interests of society cannot continue for long. It is sure to provoke oppositions from that section, those personality is crushed and rights frustrated. Conclusion. A combination of the idealistic theory and the social welfare theory is the best explanation of the nature of rights. Individual good and social good go together. There can be no divorce between the two. Society is an organic unity. Parts depend upon the whole, and the whole depends upon the parts. Welfare of the community is built upon the welfare of the individual, and when both rise simultaneously, they rise towards a moral stature. It means the regeneration of both the individual and society. A moral man makes a moral society, means a moral man. Neither can do without the other.